number 16, the people of the state of New York versus Elijah Foster-Bey. Good afternoon, counsel.
Good afternoon. May it please the court, Dina Zlok-Zauer, on behalf of appellant, I'd like to reserve 2 minutes of rebuttal time.
Yes, of course.
It was error for the court below to summarily deny appellant's motion to preclude the DNA evidence or for a Frye hearing when no court in any jurisdiction...
Counsel, to go back to something I think Judge Stein was getting at earlier, which is, I think, where you're going now, which is how much is enough, right? How much is enough to trigger a Frye hearing? And it seems like it's very hard to disassociate the test, that test, from the technology, and I think we've been talking about the timing of when this case was brought. So what's the literature? What's the state of the literature at that point? How many decisions have there been, particularly appellate divisions, I think Judge Stein mentioned, the timing of when that case, et cetera. And then you apply these factors which the court has laid out. A lot of them seem fairly commonsensical, you know, in the Wesley concurrence of Judge Kaye, and you arrive, I think, at a conclusion. So to me, it seems that how much is enough is always going to be affected by those variables, right? So I don't think anyone here in these cases, you, are asking us for a rule that says one court case isn't enough, right? I mean, because you'd have to look at a lot of different variables and this technology, right? Is that fair?
I'm asking the court to hold what it has held in the past, which is at least one inquiry is absolutely necessary, and here there was none.
Okay, so your rule would be an at least one rule.
For purposes of this case,
at
least one.
And I think
I'm not saying that that's the rule for every other case.
And I think that's my point that I'm trying to get at is that would be the rule here, and given your arguments, which you've laid out very well in your brief, at the state of this technology at this time and what the court decisions were. You know, now we fast forward out however many years from now, they don't use this technology anymore. Totally different issues would come up with the DNA, whatever they're doing right now, right? So this would be a test and an analysis based on your facts and circumstances and the technologies that existed at that time.
Mm-hmm. And allow me to just contextualize this a little. FST was launched in July of 2011. Testing in this case was completed in September of 2011, 3 months in, early days. No scholarship yet. As then Chief Judge Kaye said in her concurrence in Wesley, it's too early. It's too early to establish an opposition to it. It's too early. No appellate court had rendered a decision, as Your Honor just pointed out. And of course, this was novel.
Wasn't the core, though, of the FST criticism that I would draw from Judge Kaye is that she said that if you have a proprietary interest in the method being examined, then your opinion can't be considered dispositive. So if OCME is the only one who's using it and it's what they developed, then they can't be considered the be-all and the end-all. They can't be the definitive opinion on it. And since they're the only ones who've ever seen it or used it, it's almost impossible to judge it.
Right, there's an implicit bias in your own self-validation, and it goes contrary to the idea that it's the general scientific community that needs to have a consensus about this. It's not just your own.
Did the Commission on Forensic Science approve those validation studies?
So the Commission, the DNA subcommittee, to be exact, approved what was presented to them, and that wasn't a complete set of information we learned later. And also, in particular, for this particular case, the validation studies that were presented to the DNA subcommittee were limited to 25 picograms and up. The minute amount at issue here is 16.3. That was never validated by OCME, and it was never approved of by the DNA subcommittee. And then what the information that was given to the DNA subcommittee was apparently incomplete. There had been changes made to the source code, to the computer programming of FST after its approval. Changes were made to the protocol. At least one of the members of the committee said that there wasn't enough time to actually review all the information presented. But again, it's self-validation, and a state agency that is really tasked at accreditation cannot be a substitute for Frye inquiry.
I wasn't suggesting a substitute.
Well, here, that's the only thing that the people actually argued. I mean, and in fact, it's the only thing that was before the court was a decision in Garcia.
But it's certainly something you'd consider, I think. That
It's one of many factors, as is, scholarship, as is appellate review, as is the opinions of other experts, be that on the papers or at a hearing. This court has said again and again, it has to be a combination of sources, and we've got to give this time to develop so that a record can be before a court to render a decision.
The other argument I understand in favor of the FST is that it applied what's known as Bayesian analysis based on Thomas Bayes and statistical analysis and probability analysis to develop a likelihood ratio, and that those formulas are standard mathematical formulas that are relied on in a broad range of fields, and there's nothing unusual about them.
All of science involves theories and principles that have been established a long time ago. Let's just look at the Frye case. The Frye case involved blood pressure and whether you can measure someone's blood pressure and whether you can apply that to the truthfulness of their statements. No one argued that the diagnostic ability of measuring blood pressure, that wasn't novel at the time. It's the application, yes. Likelihood ratios, Cardinal Bayes developed the idea of likelihood ratios a long time ago. But it's their application here in this context that is novel. And what is particularly novel here is the way that the OCME programmed the stochastic effect rates.
Okay, tell us what you mean by that.
What I mean by that is, so this is a complicated mathematical, based on Bayes' theorem, software program.
We accept it's complicated, but trust me.
That
But
uses-
tell us what you mean by stochastic effects and what you mean by what you're saying to us.
So it takes what was then already controversial, the results of LCN testing, and takes those results. In this case, it was tested on 15 locations. There was only information for 7 of them, so a lot of it was missing. And it takes that profile that's developed by LCN and then tries to calculate the likelihood of the suspect being one of 2 or 3 contributors. And that's what this software program was designed to do. And the reason it was designed to do that, and the reason it's novel actually, is before that, the OCME, all it could say was, the person cannot be excluded as a contributor. And to add mathematical meaning to that, to assist the jury, they developed a brand new software program. Another reason why it's novel. And then they copyrighted it. Another reason why we know it's novel. And then they sought to get approval for it, et cetera, et cetera. Clearly novel. And so what it does is it then comes up with
the novelty aspect of this seems to be self-evident to me as to FST, but the reliability is a different question.
Okay, so why is FST not reliable? Because it has been criticized heavily for basing its estimates on the stochastic effects on pristine lab-generated samples, not on real-world samples that actually involve the degradation that we see.
And that was a criticism that was made by Mr. Boudouet?
No,
Dr. Boudouet? No? Where did that criticism come from?
That criticism comes from, at a later time than here, because we didn't get a chance of a Frye hearing. It comes from out of Collins and other...
Okay. So this trial took place in 2013. Collins was in 2015, but the appellate division had Collins in front of it in 2018 when it reviewed it.
Correct. And the old decision in Collins is actually earlier.
I see. Okay.
Thank you, counsel.
Good afternoon. My name is Seth Lieberman. There's something deeply wrong about reviewing the propriety of the trial court's Frye decision based on information that wasn't presented to it.
Well, but isn't that the point? Was that the defendants were seeking to present information to the court?
No, Your Honor, the people had presented, and the defense was aware at the time of decisions that it held that both LCN and FST were generally accepted.
Let's talk about FST. What were those decisions? What courts were they from, and what did they rely on to make their determinations?
With respect to FST, there was a decision in Garcia, there was a decision in Brissett.
Yes, but what were those decisions based upon? Were they
Yes,
based
they
upon?
reviewed a decision by the New York State Commission on Forensic Science, the National Forensic Science Technology Center, which also looked at these technologies. According to the decision on Garcia, numerous scientific groups had peer-reviewed and accepted the validity of FST. That's what the court said. If this defendant wanted to show otherwise in order to get a hearing, in order to put into play the notion that it wasn't generally accepted, because you already had courts that had held that were generally accepted, then the defense should have said something to indicate that there was a problem with those previous decisions. And what the defense said in his papers was totally inadequate. All he said was, well, there wasn't any appellate decision cited. That's not a legal requirement. He said they didn't cite to the opinion of the national scientific community. That's not the legal standard. It's not the entire national scientific community that's supposed to be looking at this. It's the relevant scientific community. With respect to FST, he didn't provide any documentation challenging it. And with respect to the LCN, all he presented was this one article, which the main author had testified at the Frye hearing in Megnath, and the Megnath court had implicitly rejected that expert's testimony. And also that decision, that article referred to a United Kingdom Commission study of LCN, which had concluded that that could be relied upon, that was robust, and therefore could be used in criminal cases. So now the defense, for the first time, is bringing in all this new information and saying, oh, see, that's why this Frye court made the wrong decision. But that can't be the basis for determining whether the Frye court properly exercised its discretion. It has to be based on what information was presented it. Not only that, the defendant is relying on information that wasn't even in existence at the time of the Frye decision.
So could the appellate division consider the Collins decision?
Absolutely not, because
That's your position?
yes, because listen, this is shifting. It's a shifting.
But doesn't the Collins decision at least suggest that maybe the conversation hadn't played out yet?
No, because first of all, you have an initial decision in Garcia, which had reviewed some of the literature. Then you have Rodriguez, which held that it was generally accepted. So now you have another court. And
But
certainly,
those are all trial-level courts. So now the appellate division reviews the case law that's out there at the time the case comes to it. And the way I understand what you're saying is they can't look at that case law?
Your Honor, no, because, and I'm telling
I'm
you.
not saying that they have to look at it in terms of saying, okay, for its factual determinations. It's a little bit different. But they can look at it and say, well, the standard's been applied differently here in this instance than was applied in this other case. Otherwise, under your theory, the only thing that they could look at would be everything that happened in 2013, and that would be it.
No, the only thing they could look at, because these are appellate courts, they're not, it's not de novo review. What they can look at were the facts that were before the court when it made its decision. That is how you determine whether a court properly exercises discretion. Just as in a Wade hearing or a Huntley hearing, you can only rely on the evidence.
I do understand your argument. I understand what you're saying. I don't know if I entirely agree with it. There's a difference in different cases, but I understand.
And Your Honor, this court has indicated, and other courts have stated, and maybe this court has stated as well, that the issue is what is the state of knowledge at the time that the Frye court is making its decision. You can't look at developments past that, and it's not as if the defendant is without any source of review. He can always raise a claim in a 440 of newly discovered evidence, or if the defense attorney didn't present sufficient information to the Frye court, a claim of ineffective assistance of counsel. But in this particular case, where you had two decisions stating that, one stating that after a Frye test, a Frye hearing, that LCN was generally accepted, several courts reviewing the literature based on that review, stating that...
What was there on FST at the time?
There was the New York State Commission on Forensic Science. There was the National Forensic Science Technology Center.
And wasn't there some indication that that was like a black box, how the internal software? Well,
first of all, that is also not information that was presented to this Frye court.
That's getting back to my point, and my point is your adversary talked about that there were 3 months between the time that FST started being used until it was used in this case. How is that enough time to know what the general acceptance is in the scientific community?
The Frye decision came out well over a year afterwards. How could it be relevant that it was 2 months later? The court was reviewing the issue months after it happened, and so it can't be that just because 2 months had passed, that's the way to review it. You have all this more knowledge that came forth after those 2 months. So I'm not really understanding the defense point.
So, counsel, to understand, we can all take a breath here. To understand your rule, what are you saying a defendant could put forward that would satisfy their burden to get a Frye hearing ordered by the court?
Well, if insofar as...
These particular circumstances, given the time frame and what was available.
If the defense had pointed out, as he tried to do in his appellate brief, flaws in the reasoning of the courts that had concluded that these technologies were generally accepted, or had presented facts to the court that had not been considered by those other courts, that suggested that these initial courts, both Garcia and Megnath, had gotten it wrong, then that would have given the Frye court in this case a reason to conclude that perhaps a Frye hearing was needed in this case. But in this particular case, the defendant sets out all these facts in his brief. Some of those facts actually were available at the time of the Frye decision in this case. He could have presented those facts in his materials, but he didn't. And so what is the trial court supposed to do? It's not the trial court's responsibility to go out and do the research.
What are the facts that were available at the time that the defendant could have presented that would have entitled him to a Frye hearing?
I'm not saying that there were any such facts, but the defense is making those arguments.
Well, I thought you just said, maybe I misunderstood you, that there were some of the facts that the defendant is pointing to now that were available to the defendant at the time that would have entitled the defendant to a Frye hearing.
That you misunderstood. I wasn't saying that it would have entitled him to a Frye hearing.
So there were no facts available to the defendant at the time that would have entitled him to a fact hearing. It has to be one or the other.
No, actually, I don't, the thing is, I'm not arguing.
What you're saying is that there were facts that were available that he could have put forth.
Exactly.
That he didn't put forth, that would have at least raised the issue.
Okay, but
Exactly.
what
At
were
least
those facts? I think that's the question. Given the rule that I think you're trying to propose here, what is it that defendant at that time frame could have put forward?
I am not saying that there were any such facts, but there are facts in the defendant's brief at this point that were available at the time of the Frye decision.
What are those facts? I think that's the question.
Okay,
that we're
I understand.
Trying to get answered.
I understand. So, I mean, I can't really recall offhand, but there are.
For example, that it was only 3 months old, this technology.
Or the articles that are cited in her brief that were published before the date in this case, for example.
So I see your red lights on, and I just didn't know if you wanted to comment on at all on harmlessness.
Yes, I do. And this was a case of absolutely overwhelming evidence of the defendant's guilt. The main thing being that a bullet recovered from the officer's calf was matched to this 7-shot revolver that was found at the scene, which was not a police-issued gun. The defendant himself made a statement that he had possessed the gun, taken it out as he was running up the steps. The officers had seen the defendant firing at the officers, and in contrast, the DNA evidence was really relatively weak, given that the expert couldn't even say that the defendant was in fact a contributor to the DNA material for a variety of reasons. And also, the issue, there was no issue with respect to really whether this defendant had possessed the gun. If the issue was whether the defendant had intentionally pulled the trigger, that DNA evidence didn't prove that. It was because you merely have a presence of DNA on the trigger, which could have certainly happened months before this incident ever happened. So in this particular case, the DNA evidence was really of very little weight. Thank you.
Thank you, counsel. Counsel?
I think we need to first point out that defense counsel didn't have the burden to show a non-general acceptance of this. The burden is squarely on the proponent, and the proponent of this technique must establish that there's general acceptance. You can't shift the burden now and make circular arguments that...
But is that the same burden as the burden, as a showing necessary to have it be an abuse of discretion not to grant the hearing?
What happened here, yes, because counsel not only filed a lengthy motion with a memorandum of law, he pointed out that that OCME was the only entity using both of these technologies. He pointed out that there had been no external review. He included an article from the architect of the FBI CODA system, Professor Boudol, and he also referenced an affidavit he would be seeking from an expert if he was given the opportunity for it. And what did the people do in opposition? Did the people submit any articles from any leading scholars and scientists to say that, yes, this is generally accepted, you don't need to have a Frye inquiry here? No. What did they do? They included 4 trial court decisions, none of which had held a Frye inquiry, and said that's it. Just by judicial fiat, just let this in.
Counsel, do you want to comment on your adversary's characterization of the evidence in this case?
Absolutely. This was not harmless error. In the oral swab motion, the prosecution stated, and I quote, that the DNA on the revolver was crucial, a crucial part of the prosecution. It went to whether, I quote, the defendant possessed the gun, and here it's very important, pulled the trigger, undermining his claim of an accidental shooting. The DNA evidence here was minute, and it came from the trigger ridges. That's why they wanted it in. And then the OCME assistant director, no less, testified repeatedly that the 1,100 times more likelihood ratio was very strong support, I quote, The prosecutor, in his opening and in summation, repeatedly referenced that number, 1,100 times more
Can
likely.
you go back how the DNA established the pressure on the trigger?
Pardon?
How the DNA established or suggested to the jury that indeed he had pulled the trigger as opposed to dropped the gun and it goes off accidentally?
Precisely, yes. That was the whole purpose of the DNA evidence here.
I'm saying, how did it do that?
Oh, how did it do that? By the OCME assistant director testifying and then the prosecutor repeating it in opening and summation, that the likelihood that the appellant, the defendant, and one unknown contributor, it was 1,100 times more likely that the defendant and one unknown contributor contributed to the DNA on the trigger ridges than two unknown contributors. And it was that likelihood ratio, by the way, and this probability evidence that the jury requested twice in two separate notes to hear again. This is the second trial in this case. The first one was deadlocked. This jury in the second trial was deadlocked as well. They sent in 40 notes, 2 notes about probability. This was critical evidence in this case and led to my client's conviction.
Thank you, counsel.